Okay, what can I do to help you all today?
Get us off of your docket is what you could do. Go ahead, Lacey. Start talking. Got plenty of responses. Objection. Blah, 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 blah.
Okay, what can I do to help you all today?
Yes, sir.
Get us off of your docket is what you could do. Go ahead, Lacey. Start talking.
That's pretty specific. Ms. Kimball?
Yes, sir.
Specific.
Go ahead, Ms. Kimball.
A custody evaluation was completed, and so we have filed a motion for drug screening and a motion for a psychological exam based upon that custody evaluation recommendations.
Blah, 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 blah.
Stop talking. You'll be able to respond in just a second. Ms. Kimball, you can go ahead and finish, and then Ms. Stiles, you'll have an opportunity to respond in just a minute.
I need to pause the hearing. I don't have an attorney. Can you give me some time to get an attorney? I haven't had adequate time to obtain an attorney, and my attorney withdrawed, and I'm going to need one appointed by the state.
That's not an option. There's nothing there unless someone's asking that someone be held in contempt and jailed, which is not something that's set in front of me. Or it's a action by the state to terminate a parent's rights or something like that. Those are the only times I have the ability to appoint an attorney for you.
Okay, then go ahead.
We also had sent discovery out as laid out in our motion sometime back. I had worked with Ms. Stiles' prior counsel and had agreed to 2 extensions. And then we ultimately never got a response, and she filed a motion for protection. She got
plenty of responses. Objection.
What's your objection? Hold on, wait a second. Ms. Stiles.
The sentencing hearing begins with the judge moving quickly through a crowded docket. This is the second courthouse of the day, but the court proceeds without delay. The case is called State versus Eric Lavoie Henderson. The judge confirms having reviewed the presentence report and immediately raises concerns. Questions follow about how long the defendant has been in jail and whether the proposed agreement truly reflects the full picture. The atmosphere shifts as the court makes clear that agreement alone is not enough. The judge's role is not passive. It is to examine, question, and determine whether justice is actually being served.
You just need to object and then let me know what your objection is. Don't yell at her.
Objection to hearsay. How do I submit my documents to you directly?
Hold on. So, Ms. Kimball, are you saying this was something that happened between counsel?
Yes, back in November. We are now setting this hearing is for our motion.
She also represents and also that there is.
Okay. So, Ms. Stiles, I'll unmute you in just a second. You need to let Ms. Kimball finish what she's saying, and then when you're talking, she'll let you say what you're saying, unless one of you has an objection that is a legal objection. You can't just talk at the other side. So, Ms. Kimball, why don't you just go ahead and finish telling me what? So you said that you're wanting a drug screen, so drug test, and do you say psychological or psychiatric? I thought you said
a psychological exam. And then we have an order to compel Ms. Stiles to turn over the responses to our discussion.
The court summarized the charges. Mr. Henderson pleaded to a 4th offense DUI, 3 counts of attempted aggravated assault, and possession of a firearm by a convicted felon. The firearm charge alone carries a possible 3 to 6 year sentence. The state explains the agreement, time served with probation, noting that any violation would trigger an 85% sentence. The judge pauses. Then comes the question that changes everything. How many prior convictions does the defendant have? The answer, 41. The judge reacts immediately, stating clearly that approving this agreement would not be doing the court's job.
Every request to provide dates for a deposition and for attorney's fees for $1,500.
All right. So Ms. Stiles, I'm sending you a prompt to unmute. If you just unmute yourself, you can respond. What is your response to those things? Let's go with the drug screening part. Do you have an objection to taking a drug test?
I'm not going to pay for it because I'll tell you up front, I'll file for marijuana.
When was the last
But
time?
I'm happy to take it on
When was the last
expense.
time you took marijuana?
I use marijuana daily. All day, every day. And it's legal in what states? California. So we can either get there or not get there. Your choice tonight.
Um,
So I'm glad to take the drug test.
Stop.
Okay, go. It's going to be on his expense, but I'm
Stop. I'm pretty low key. We're in court.
fed up with Miss Kimball.
You need to be respectful. So
I'm fed
you can just, if you're going to use
Respect.
my last name, that's fine. Just say Judge Tanike. Okay, it's pretty easy. So you use.
The judge announces a sentencing hearing will be held. The presentence report is central. The court begins reading the defendant's criminal history aloud, conviction by conviction, spanning decades. Violations include repeated DUIs, revoked licenses, theft, assault, vandalism, evading arrest, harassment, and more. The list continues uninterrupted, reaching back to the early 1980s. The judge clarifies these are not all felonies, but 41 separate convictions. Each entry reinforces the same concern. This record exists so the court can understand who stands before it. Based on what is presented, the judge states plainly that approval cannot be given.
Marijuana all day, every day.
Not really all day, every day, but I use it daily, if that helps you with your interpretations. Mr. Low-Key Honorable Judge Tanike.
I'm not interpreting. I just said what you said.
Okay.
What is your response to the request for a psychological evaluation?
Not doing it, and you cannot force me to do it. You cannot physically make me go and show up and partake in anything that I do not want to partake in. Yes or no? Do you agree or not agree?
You don't get to ask me questions right now. I'm asking your position.
That's my response to you.
Okay.
You will not get any. I'm not doing a psych eval, and you cannot make it mandatory.
Interesting. In terms of the motion to compel, where they're talking about discovery, what's your response to their motion to compel?
Have you read their discovery? When are you going to view my videos?
Ma'am, you need to answer my question.
I answered your goddamn question.
After allowing time for review, the court explains its position. The presentence report is designed to give background necessary for a proper determination. The judge expresses concern that the state may not have fully considered all information contained in the report. The matter proceeds to formal sentencing. The report is introduced as an exhibit, authenticated without testimony. The state confirms it has no additional proof and will rely on argument. Defense counsel indicates the defendant will testify. The judge calls Mr. Henderson forward, places him under oath, and begins questioning to clarify the record before the court moves any further.
All right. So I'm going to warn you that it is completely inappropriate to swear like that in court. You need to take yourself, you need to put yourself back on camera. Thank you. I'm not going to allow that. So if you do that again, I'm going to sanction you $100 for every time that you swear in court, because that's not appropriate. You just need to not do it. You can answer the question and be respectful to Ms. Kimball and to the court. And I'm not going to tell you how to answer, but you can just say whether or not you're in agreement with something. In terms of the motion to compel, I haven't heard it yet. So I'm just trying to find out from a cursory standpoint, what your position is on these 4 issues so that I can figure out.
Under oath, Eric Lavoie Henderson introduces himself and confirms his date of birth. The judge explains that the court is rejecting the time-served offer due to community safety concerns. The judge references the 41 offenses and addresses the defendant directly. Mr. Henderson claims some charges belong to his son, who shared the same name. He explains past confusion between their records and insists some entries are incorrect. The judge warns him carefully. He is under oath. Any dishonesty could bring serious consequences. The defendant acknowledges he does have a criminal history. The court proceeds methodically, charge by charge, seeking clarity.
If there are partial agreements or not, it sounds like there aren't. So based upon your response, I'm going to take it that you're not in agreement with their motion to compel. In terms of their request for deposition dates, what's your response to that? I sent you a prompt to unmute yourself.
What dates?
Ms. Kimball, do you have proposed dates?
I can. I would propose.
And whose expense? Mine? Because if it's mine, I'm not fucking doing it. Sanction, give me $100 fee. Woo,
Okay,
woo.
well, so I am finding you in direct contempt.
Okay, 1 fine.
Finding you $100.
Okay, make it 2. Damn, I said 2 words.
Ma'am, I don't think you want to do this. At least the people in the courtroom seem to think you don't want to do this. I will, not because you're requesting it, but because you're not following.
The judge questions Mr. Henderson about specific convictions, asking whether each offense belongs to him. The defendant confirms multiple DUIs, probation matters, reckless driving, assault, theft, and vandalism. Some incidents, he explains, involved relatives or overlapping cases. The court pauses to establish timelines, including the age and passing of the defendant's son in 2019. The judge carefully distinguishes events before and after that date. The goal is accuracy, not assumption. The court seeks to determine which convictions are validly attributed to the defendant and which may be mistaken identity. Each response is weighed, slowly and deliberately, as the record is refined in open court.
The order, as I said, sanction you.
Please do.
Let me do it. So that's
Please.
$200.
Here, I'm sure she wants my apartment number, right? Turn it to Miss Kimball. You're going to want that.
Stop. That's not something that she asked for. Ms. Kimball, what date?
No,
What date?
everybody else.
I would propose August 30th or September 2nd.
Okay.
How long?
Are you wanting how long? That's a valid question. Is it half day, an hour, 2 hours? What are you
I
anticipating?
would anticipate a full day.
Okay.
So what, the
Ms.
30th or the 2nd?
Yep. Which of those dates works better for you, Ms. Stiles?
What time, dumbass? 3 contempts.
You're correct. That is 3.
Yep.
Supposed to start at 9 a.m.
What date?
So that question is to you. Never mind.
Said what
I'm not-
time?
I'm not gonna let you
Time,
pick.
date? You know, these
I'm not
things.
gonna let you look. You don't get to do this for your own pocketbook. I'm muting you for. All right, I'm going to count that as another violation. So, in terms of the request for the deposition, she didn't have any objection. I don't know for my own record that she opted out after flipping me off. I won't comment. So I'm going to grant the request for August the 30th at 9 a.m. in your office. Miss Kimball, sorry. you can just put as much specificity as appropriate for in order that, I mean, it would normally have your address and time and everything like that, but just so there's no confusion, since she disappeared, I will sign an order that orders that the deposition take place. Let me go back, since she left, and I heard her responses. I was going to take testimony from your client and from her. Do you need any testimony from your client about the drug screening? So I haven't read the custody evaluation, but if they're requesting it, your client's asking for it, she's, whether she's going to pass or fail, is not the determinative factor. Because you may want it to see if there's something other than marijuana. So I'm going to grant that request. I don't need testimony from a client about that. In terms of the psychological evaluation, I'm just going to allow your argument.
Your Honor, I think based on the presentation today of Ms. Stiles and the custody evaluation report from Mr. Bouchard, I think it's apparent that there could be some mental health issues that would obviously impact custody and access to the child. So we believe a psychological evaluation would be necessary. Furthermore, Ms. Stiles is not in possession of any of her children at this point, and has not been paying support on AILA for a little over a year now. And so we would be requesting, she's also received the tax stimulus funds and income tax returns for claiming the children. So we would ask that the expenses be put on Ms. Stiles to pay for that.
I'm sorry, to pay for what part specifically?
For the drug test and the psychological evaluation.
Because she's been receiving that money.
Yes, sir.
Okay. I think I know the answer, but I don't want to assume. Mr. Parnell, have you received any of that money? Does she provide even $100 to you?
No, sir.
Thanks. I was taking your attorney's representation as being true. But sometimes it helps me just to understand. Okay, in the motion to compel, did she provide any response? She had an attorney as recently as last month.
There were
recently as the last 3 weeks, but it's been a couple days.
there were some, I allowed 2 extensions by agreement, Rule 11 agreement. The responses we got were some partially answered interrogatories, but they weren't unsigned. But for the interrogatories, the documents, everything was just kind of blanket objected to. For, I believe it was for harassment was the objection. So, and we received no documents at all. Ms. Bertrand did represent that there could be some documents in her office, but that was when she was still on the case.
And were there objections made to the interrogatories?
Yes, sir. Objections to undue burden, unnecessary expense, harassment, or annoyance.
Okay, let me pull them up. So in reviewing them, one is about persons expected to testify at trial, identity and location of employers in the last 2 years, identity of people she's had an intimate relationship with for a relatively 5-year period. Mental health and physical health care providers or objections, but then that was actually answered, but just names, not any address or phone numbers or anything like that. Income questions not answered. Monthly living expenses says litigation, auto payment, cell phone. Did you get anything? Did you get any numbers, or is that all you got?
That's all we got.
Okay, she objected to why the prior order should not be modified. She objected to a question about the child's present living environment and visitation for the temporary orders, if that's not in the best interest statewide generally. She objected to that. She provided a partial answer. She objected to child support questions. She objected to counseling and psychiatric questions.